the Cleveland Metropolitan Bar Association. Thank you for tuning in to today's CLE. We have 1 hour for you from 12 to 1 o'clock. If you are here to get that credit, you have to do two things. Complete the polls that will appear on screen today. So usually we have like a random poll for you to complete, but today we have 2 polls that are pertinent to the program today. So when prompted by our speaker, just be sure to complete those when they pop up on your screen, and complete the CLE survey that will be emailed to you after we conclude. If you have any questions during the session today, you can drop those into the chat or the Q&A, and we will address those when they come in or towards the end of the session. So with that, we can go ahead and introduce our speaker today, none other than Ian Friedman. He is the founding and managing partner of Friedman Nemecek Long Grant. He is a criminal defense lawyer that has represented clients in just about every state and internationally. The Ohio Association of Criminal Defense Lawyers named him first ever Lawyer of the Year after his presidency and work to revamp Ohio's criminal discovery rules. Ian has served as the president of many organizations, including the Cleveland Metropolitan Bar Association and American Board of Criminal Lawyers. He is also taught as a law professor for the last 18 years at Cleveland State University, where he teaches cybercrime, but he's here with us today to talk about gun laws and all that good stuff. So Ian, thank you very much for being here with us this afternoon. Happy to have you. The floor is all yours.
Thanks, Dominica. So good afternoon, everyone. It's always an honor to be speaking with colleagues, and particularly so many. This morning, Dominica and I were talking, and I asked her, I said, so what do we have, about 10 or so people? And she thought I was joking. I was not. To have in excess of 80 people on this topic is very impressive, and I appreciate everyone being here. As we go through this, as Dominica said, there will be 2 kind of interactive questions just to kind of see what your opinions are on a particular issue. But as we're going through it, please feel free to ask any questions you have. I'll try and answer them in real time. If I can, I will. And if I cannot, or it's going to take too long, I'm certainly happy to address them afterwards. So with that, exploring firearms and personal defense laws in criminal, domestic, and civil contexts for 2024. All right. So what we're going to talk about today are individual rights, individual responsibilities, the reality of how defense works, firearm laws in Ohio, how they're applicable in all kinds of the different areas of law, the reach, who do these laws reach, who do they affect, and also responsibilities. Again, now, if you're questioning why I put responsibilities, is that a mistake? No, it is not a mistake. I think there is no greater responsibility that one can have when they are contemplating carrying a firearm. And so just as you can't be overly cautious, overly prepared, overly responsible, I do not think you can be. And so responsibility, responsibility, responsibility. And that's why I'm glad that so many are here today to kind of listen to this, because this really is what we're talking about, is what is our client's right, an individual's right, a friend and family's right, your right to carry a gun. But with that, what is the responsibility that is carried? So when we first look at the Ohio Constitution, Article 1, Section 4, and this is just to kind of get the base, we the people have the right to bear arms for defense and security. That goes back to the very beginning. It is a right that many are very passionate about, but it also brings great divisiveness within the community. And we always hear about gun rights, firearm rights, and have we gone too far, and so forth. This presentation is not designed to take any position at all. It's simply an education on, as we said, the rights and responsibilities and if someone chooses to carry it, or as a lawyer when we are asked to guide our clients, because many of you, I'm sure, are presented with questions from clients that, can I do this, or what happens if I do that? That's really what we're going to talk about today, is how to answer those questions. So as of June 13th, 2022, we became what was called a constitutional state, or a permitless carry state. So sometimes we hear constitutional carry. And it used to be that if you wanted to carry a firearm, you had to have a concealed permit with you, CCW. But now, since that date in 2022, people no longer need the CCW. And what it does is it basically says if you're 21 years or older and you're not exempted by any certain factors, you can carry without having any particularized training or needing to get any license by the government. Now, those exclusions that are there are things like certain criminal histories. And not all criminal offenses make someone exempt. Most do, but not all. If someone has been declared mentally incompetent, or they've got a protective order against them, or the local sheriff's department has deemed that they are an inappropriate person to carry a firearm, just being in constitutional carry state does not override that. They're still subject to those sorts of limitations. And of course, just because it's a constitutional carry state doesn't mean that forbidden zones, so like governmental buildings, schools, houses of worship, that those are going to be permissible merely because of the status of our state, which, by the way, makes us the 23rd state in the country to become a constitutional carry state. Now, I did say house of worship, and you may hear sometimes that people say, well, yeah, people carry guns in my church or synagogue or mosque. There is an automatic exemption unless the authoritative body within that house of worship gives express permission to carry that firearm. So there is a way to do it, but it's not automatic merely because you are an Ohio citizen subject to constitutional carry rights and protections. So I think right away what we're going to talk about is self-defense in Ohio, and really kind of get into what it is, what constitutes self-defense, and also what is not self-defense. The main question that I'm presented with as a criminal defense lawyer is, before any case, I'll get people who will call and they'll say, you know, if someone's coming at me this way and I use my gun, is that fine? And I think what's really important to note here within the realm of self-defense is that there is no absolute answer, and there is no broad brush by which to paint. Every case is taken on its own merits on a very fact-specific basis. And what may be constituting self-defense in one of the 88 Ohio counties may be very different than another one of the 88 counties. And so what I tell people all the time is, don't set up this scenario in your brain as to what's going to pass legal scrutiny and try and force the situation to meet that standard. First off, it never goes down as planned. It's always going to be reactive. And I think that knowing the situation and thinking ahead is the best thing that anyone can do. Tell clients who decide to carry firearms or keep a firearm at home for personal protection, the best thing that they can do is train and think about these scenarios ahead of time, so that it's not what you don't want is the first time you're presented with a defense situation, you have to figure it out at that time for the very first time. You're not going to do it right. Everyone thinks that, you know, they use a gun, they go get their CCW or their constitutional carry, they just go and buy a gun and everything's going to go down like it does on television. You shoot them in the leg, the person's on the ground, police come, pat it on the back, and everything's fine. And that's not what happens. Police unions have rules when there's a police-involved shooting. They don't make a statement right away. They're given a period of time, sometimes 48 hours, so that they can get their thoughts together, because they, who are trained to carry, are in a surreal state, and their answers may not necessarily fit the facts of the case. So what I have had from people who have used their firearms before in defense situations, they've lost all concept of reality. Everything's very surreal. They may have lost bodily function entirely, and what they may recall is very different than what actually did happen. And they're not trying to lie. It's just their perception of reality has been altered. And so training with qualified individuals is what I tell people to do all the time. Again, it gets back to responsibility. If you're going to carry a firearm, understand what that means. You are putting yourself in a position, your client's putting themselves in a position where they are contemplating taking one's life, because you never pull out a gun unless you intend to use it, and using it means potentially taking someone's life. And so with that, that responsibility also includes, there's no such thing as too much training. Okay? And self-defense, so that you're not dealing with it for the first time, is as follows. Okay, so what is it? This is a situation, you just saw a knife attacker, but right here in this courtroom, really what you're seeing on the screen are kind of the 4 factors that are looked at when determining whether or not self-defense exists. But let me just read to you the definition, because I think it's important. Whether self-defense can be used as a legal defense in Ohio when a person reasonably believes, and we're going to come back to that word reasonably, that they or someone else is facing an imminent threat. So imminent, again, another operative word, an imminent threat of death or serious bodily harm, in other words, serious. Using force has to be necessary to prevent that harm. And that's what's critical. We're going to talk about imminent threat or danger. You can't argue that I was facing this threat of serious physical harm if a person says, I'm going to come back tomorrow and kick your butt. That doesn't work. It has to be the immediacy. If you don't act, you or someone else that you are acting to defend is going to sustain that serious physical harm. Now that meshes into proportionality, because the seriousness factor does, because you can't show up to a fist fight with a gun and say that that is proportionate. So one has to meet the other. Now, arguments can easily be made, and this is why I'm saying you can't just paint with a broad brush. There are instances, you read them all the time in the newspaper, where someone sustains a punch, one punch. They fall down onto the ground, they hit their head, and they die. Okay? So might someone have a reasonable fear of that? Well, I would look at that person, as would a jury, and consider what is reasonable for that person. The person who is claiming self-defense, what's reasonable for that? And what's reasonable for one person, so say someone's standing right next to me, who's 6'4", worked out, they may be skilled in jiu-jitsu, they've got all sorts of training. What's reasonable for them is very different from me. A shorter guy, I've got a bad arm, I've got a broken neck, broken back, all of these things. I have a different reasonableness, a different viewpoint. And that's why every case is looked at on its own merits. Now, would I show up with advance notice and someone says, I'm going to hit you? If you can walk away from that, of course you do. And we'll talk about duty to retreat in a moment. But utilizing the firearm is the last thing. And always tell your clients that, because they're coming into the question of, if I do this, which is coming into it, if we always want them to come out of it. So it is a last option that I always tell my clients. Anything that you can do to avoid it, do it. And that's what absolutely we tell them. So necessity is, was there a reasonable alternative? Could you have gone away? Again, we'll talk about duty to retreat. Were there other things? Could you have called the police? Could you have hailed the police officer that's 10 feet away and could have just walked in there? So these are the sorts of things that are looked at. And one thing that you cannot be is the initial aggressor. You can't go into the situation as the aggressor and then claim that you acted in self-defense. Now, sometimes when they get a little gray is where you're in a confrontation, and maybe verbal, maybe you started it. The other person escalates that situation, and now the landscape has changed, and you act differently. You act with a different intent from which you entered into that situation. That may pass scrutiny, but the rule is very clear that someone who is going to bring a self-defense claim cannot be the initial aggressor. So you can't go up to someone, gun drawn, come into that situation, and then all of a sudden say, well, I acted in self-defense when he pulled the gun out in response. That you're not even going to get a jury instruction. All right. So pursuant to the Ohio Revised Code, and really what we're talking about now, we're doing the criminal section now. We'll talk a little bit about civil, going to even get into gun trust at the very end of this. But pursuant to Title 29 of the Ohio Revised Code, which is the criminal section, there is no duty to retreat in Ohio. Many of you have heard the term stand your ground. We in Ohio are now considered a stand your ground state with no duty to retreat when faced with a situation where all of the elements for self-defense are present. So it used to be, even when you were at your home, before the laws were changed, that you had a duty to retreat. There was a time when you had a duty to retreat even in your home. It was realized that was not because you could have someone breaking in the front of your house. That duty to retreat, you'd have to run out the back, and who was out there to meet you? You didn't know. So the castle doctrine came first, and what that stated was that there's no duty to retreat where you have a lawful right to be present in your own residence or in your own vehicle. If you are a passenger in a vehicle of family and you have a lawful right to be there, that extends to you as well. And the law presumes, if you're in your home, you're in your vehicle, you have that right. The law presumes that you acted in self-defense when someone unlawfully enters your home. So if someone is breaking into your house, of course, the question, we're going to watch a video here in a little bit, but the question becomes, when does it become okay to act in self-defense? Is that if the person's walking up onto my lawn and I think they're coming into the house, is that enough? Yeah, probably not. There's going to be a debate about that back in the jury room if you get an instruction in. If they're pounding on the door, if they've cut the screen, if they've come through the window, or if they've met you in the dining room and woken you up to the alarm going off. All of those are different stages. And the one thing that you may take away from this presentation is there's an awful lot to think about when possessing or thinking about utilizing a firearm or relying upon a firearm for safety. There is. But if you, I tell people all the time, if you go through the exercise of asking yourself and going through your scenarios of the day, it becomes second nature. So when someone wakes up, I tell my clients, you need to think about it. If you're going to carry a firearm, you have to think about what you're going to do that day from the moment you leave the home until the moment that you get home and lock your gun back up. Where are you going that day? Are you going to a place that has signs that say you can't have your gun that day? Are you going to a school? Are you going to be in a car where you have kids in the car? When the kids are in the car, you're going to be running into the store. The way that you carry your gun, is it going to be printing in your jacket? Meaning, is it going to be showing where it is? There's all of these things that you have to go through, and it might seem overwhelming for people at the start, but after you do it for a couple of weeks, it really just becomes just a way of thought, but it's important to do it. Those that get into trouble, those who come to offices of criminal defense lawyers, usually have not really thought through. What we see are people who are newer to firearms and not the people that have been so used to carrying them, going out to eat and going through just kind of the everyday scenarios. So again, responsibility. The responsibility is to go through your entire day, map it out, and eventually it just becomes how you think. So with that presumption of law at the house and in the vehicle, the only way the government would have to overcome that presumption if they were trying to seek a conviction in a case. Now, excuse me, so the case before you and the citations that you have, all of these cases I'm going to be talking about today are very recent cases, all within the last month, last couple of months, all 2024 cases. And State versus Palmer was a case where a taxi cab driver picked someone up, they took them to another town, and they got into a verbal altercation between the two of them. They ended up getting into a physical altercation. Palmer, the driver of the vehicle, ended up shooting the passenger of the vehicle. Went to trial and was unable to get a jury instruction in. And the basis for seeking that jury instruction was, seeking that self-defense was prior experiences that the driver had had with being attacked and being the subject of crime and assaults and so forth. and that was deemed to have been insufficient to get a jury instruction in. The Ohio Supreme Court, and this is a really good case to read if you want to know what really constitutes self-defense, because the Supreme Court came back, and it's important for me to read the language to you. They stated that a defendant is entitled to a self-defense jury instruction if they present legally sufficient evidence for every element of their self-defense claim. And what the court said, and really why this is important, is they stated that the burden of production to get that instruction is low, and that it can be satisfied by the state's own evidence. So you need not put on anything else. The instruction can come just based upon what the state has presented at trial. They stated that it's not the trial court's duty when seeking the instruction to determine whether or not the evidence that the defendant's going to rely upon is persuasive. It's the trial court's job only to determine whether or not that evidence is adequate to present such a defense. And could it convince a trier of fact beyond a reasonable doubt? That's it. Could it? So it's not a determination of how persuasive it is. It's just whether or not it meets kind of the minimum threshold to satisfy the elements. And then it's got to go in for an instruction to be considered by the jury. I think this next case is interesting. And this also, as I said, a recent case. And this is State v. Wilson. And the citation on this one is 2024 Ohio 776. And in that case there, force was used to repel an assault. And a warning shot, as you see from the screen, was utilized to basically say, get away, get away, get away. So this warning shot is put off, and the trial court said, you can't get an instruction in on a warning shot because you didn't have the intent to commit physical harm or to kill another person. You needed a different state of mind than what you had when you were seeking to just ward off the attack. The court looked at it and determined that that didn't make a whole lot of sense. And that pursuant to 2901.05B1 and the case law, that a person is not required to prove that they intended to harm another person in order to be entitled to a self-defense instruction. The case was remanded back to the trial court for a new trial consistent with the determination. But what they said was, again, you need not intend to harm or to kill to get instruction, right? Which makes sense. It doesn't make sense that you have to kill someone in order to get, or shoot them in order to get the instruction. Aren't we better off if warning shot gets the job done? Wouldn't we prefer that and to get a self-defense instruction? I would think so. So I think this is a very good holding on a State versus Wilson, which before, and again, using these 2024 cases, it shows you how quickly the landscape is changing in firearm law. So that's why I'm glad you're here, because we didn't have anything about shooting off warning shots until recently from our state's highest court. Now, property. Question that I'm asked a lot is, if I'm in my house and I get my car alarm, what kind of force can I use? Well, the answer to that is you can't use your firearm to preserve property, period. And so here, the picture that you see is a purse. You know, if someone's stealing your purse, they can steal your purse. And it's illegal, but you're not going to shoot them over that. If you do shoot them over that, you're going to need a lawyer to defend you for that. Texas, very different. Ohio, you cannot shoot someone if it is just a mere theft of property or tampering with property or destruction of property. All right, so you're in a criminal case, you want to raise self-defense, and the question is, how do you do it? One of the mistakes that I've seen some lawyers make is they go to trial and they just want to get that instruction in, and you can't, and the court can exclude it if you don't do it the right way. So pursuant to Ohio Rule, Criminal Rule 12.2, you've got to give written notice of intent to utilize self-defense. And it's got to state out what the evidence is, who the witnesses are, the evidence that you rely upon in raising that defense. And in a felony case, it's got to be 30 days prior to trial. In a misdemeanor case, it's got to be 14 days before trial. Again, if you don't It can be excluded. It's not a shall be excluded. It's a may be excluded unless for good cause. But you don't want to be in that position in the middle of trial where you're saying, well, we want to raise this, because the objection is going to come back automatically to say, wait a second, we didn't have notice of this. There's great prejudice now by us not having received notice. The law is very clear on that. So in a self-defense case, the question is, it used to be an affirmative defense. So if I was charged with an offense, acting in self-defense, it's on me to prove that I acted in self-defense, and that's no longer the case. So now in Ohio, that burden switches over to the prosecution pursuant to that same revised code section 2901.05B1. And when that burden switches over after that notice has been given, the prosecution now has to show beyond a reasonable doubt that the defendant did not act in self-defense. Okay, so that's a really tough burden. So the defendant is saying that they can't prove guilt beyond a reasonable doubt, but you got to add to that now in the self-defense case to even get there. The prosecution has to show beyond a reasonable doubt that there was not self-defense in that case. When we say self-defense, again, we're not just talking of oneself, we're talking about defense of others same way, and the same laws apply, the same standards apply, and so forth. So what I want to do now, and this is what Dominica was talking about as far as giving some feedback on it. And I do have to say, there's, for those of you that, you know, I put viewer discretion advised, and I didn't do it as a joke. There is no joke about the utilization of firearms and when people are struck by when they're used and so forth. It's not, you know, we use a lot of words all the time, but to actually see it can really have a negative effect on someone. And so if you are someone that does not want, no one wants to see, but if you feel that you should not see a situation where someone is struck by a bullet, then this next, these next two scenarios, particularly this first one, is something that you may not want to watch. So what you're going to see here is a situation of someone trying to break into a home, and the homeowner uses the firearm to repel the entrance into the home. And this will be a couple of minutes, and at its end, I'm going to ask you whether or not you feel, based upon what we've talked about, your understanding of self-defense law, your reason and common sense, whether or not you feel this to be a situation of self-defense or not. So, all right, here it begins.
Stop it, Allie. Boys, in the house. I'm doing it. Oh, wait. He's leaving. Hey, he's coming back. Nope, 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 I'm calling. James, she doesn't want to talk to you.
Well, he's not moving. He'll have a gun.
He broke our door in, trying to get to our daughter. Our daughter's busted in.
Okay, hold on. Did you shoot him?
Yes.
Okay. Call 911.
It's already, no, we're on the phone with him right now.
Okay, he's not moving. He ain't going nowhere.
Okay, so as the trier of fact, my question is, Dominica, if you can put out the poll, do you feel that the homeowner acted in self-defense or not? So if you just want to mark yes or no, then Dominica is going to give the results on that, so we can all see as a group through a trier of fact what kind of the group consensus is.
Waiting on just a couple more people to take the poll. Thanks, everyone. If you don't see the poll, which it looks like there might be a couple of you, you can enter your answer into the chat if you like. Yes or no. But right now, 26 people entered yes and 26 people entered no.
Wow, okay.
So, yeah, here are the results.
Wow, that's fantastic. Okay, and that really kind of, that's very interesting. So again, it goes exactly what I was saying. Every single case has got to be on its own merits, and half people think that this is defense, half don't. So very interesting. This is the sort of question that we see addressed in criminal cases. And also remember one of the things which we'll talk about in a minute. I always caution people, because again, that question is, you know, am I going to end up in jail, or is this a good shoot? Even if you get past the criminal matter, the client's going to be subjected to civil as well, the civil assessment, civil claim, and so forth. So, all right, well, thank you for that one. The very next one that we're going to do is actually the first ever CCW self-defense case that was taken out of Wisconsin. This is at a grocery store. I want you to watch this, and then I'm going to ask you to vote on this one as well. That's a little bit in speed, but you can see what's going on. So you see him at the base, and there he is with a gun in the left hand at the base of the screen. The cashier is there, instructed to get money. And now you see the gentleman right there with his right hand backing up. That's going to be a person who is acting in self-defense eventually. And what he's doing is taking his wife off screen, putting her down back behind in safe way. And now you'll see him up at the top still, entering back into the picture slowly. As you see, the person's still putting money in there. The shooter's still holding the gun. And now you see the civilian coming around and drawing his gun. He aims it at the robber, fires the gun, tries to reholster. You see the robber exiting the store, and this person was eventually apprehended. Now, I want to say a couple of things about that. First, let's vote. Dominica, if you can put that up, and then I've got a lot to say about this one. That's the different aspects to it. But on this one, was this an example of self-defense, yes or no?
1 second here. All right, 27 people said no. So this is 50-50, but one person like couldn't complete the poll. So one person did say no. So technically no wins.
So again, perfect example of just how this is viewed across the board, these sorts of issues of self-defense. So it's fascinating that on both of these, the group was split. Now, I want to, having analyzed so many of these scenarios, want to be real clear and point people to a couple of things to think about. Well, let me tell you what did happen. The Samaritan who left with his wife out of harm's way and then re-engaged was not indicted by a grand jury in Wisconsin. So there were no charges brought against this person. That's fine, but there were a lot of things that were wrong about this. And namely this, the question as to re-engaging, was he coming to the defense of others? Certainly it could be argued, and it was argued, coming to the aid of the cashier who had a gun pointed at her. So coming to defense is fine. But where there was a real problem, and it gets back to, and I use this term over and over and over, responsibility to train. Those of you who have experience with firearms may have seen what happened there. When the gentleman went to use his firearm, he drew the firearm out, went to shoot, and under that scenario, because he hadn't trained enough under stress conditions, and maybe perhaps with that particular firearm, he did not disengage the safety. So when he went to shoot, he could not discharge that firearm at first, which is why then he had to go back and try it again. He could have gotten himself killed. When he pulled out the gun and the robber saw that, that could have caused the robber to then started shooting others. So again, if you're going to carry, you have to be skilled and prepared to use it. This worked out luckily and just by luck where no one was hurt. Again, he wasn't charged. At the end of the day, you have to think about people's safety and everyone needs to go home. And that person did not act as they could have and should have under that scenario. So thank you for taking the polls in both of those. I want to talk to you about what best case scenario is. So when folks come in and all those questions are asked, talk about, well, here's the best case scenario. Best case scenario is you acted in self-defense, you're past, you're cleared of any criminal wrongdoing. And what you see here is on a scale of 1 to 10. The best scenario, 10 is, now here's a story for you that'll kind of tell it like it is. There was a restaurant owner on the near west side of Ohio who was in the restaurant about 2:15 in the morning, counting cash and doing all the receipts for the business that night. It was a Saturday night. This person was the owner was the last person at the restaurant. And when he was leaving that night, he locked up the doors, had the receipts and was going to do a deposit with the bank on Monday. And as he walked outside, all of a sudden, a gun was placed right in his chest. And he looked up and, of course, absolutely terrified, said, "Here, take the money, take the money, take the money." And the only response that this person got was just the person going, "Shh," like this, shh, this sort of just shush sort of thing. No words were said, just shh, which is absolutely terrifying. And with that gun in the owner's chest, the person was pushed and instructed to come from the front door, come around the corner, and being pushed back into an alleyway back behind the restaurant. Now, luckily for that restaurant owner, as he was backing up, he caught the back bumper of the vehicle that was parked there on the left leg, just enough to turn the body so that the right side was back here. That allowed him to draw his handgun, which was on his right side and about on his hip between 3 and 4 o'clock. Drew the gun, shot. Person still ran off, even though had numerous shots had hit target. Ran off, and about 50 to 60 yards away, the assailant was located, and it was dead on arrival. That's a very clean self-defense case in most people's book, but yet still that person had to hire counsel. That person's counsel had to meet with detectives. They had to spend a lot of money. This went on for over a year before they were finally cleared, because there were all sorts of factors that were in play with the detectives, the prosecutor's office, and so forth. So that is a perfect reason why I tell people even the best case scenario is going to be filled with anxiety. You're going to expend great resource and time financially. It's going to take its emotional toll on you. So again, the more mental preparation going through these scenarios, the better, but also be prepared for the fact that even in the best situation, cleanest, there's no avoiding a scrutiny that will go on for some time. Now, we're an open carry state too. So what does that mean? Well, constitutional carry means, right, we said that you can carry like a CCW covered, you could have your jacket over it and so forth. But if you choose to carry open in Ohio, you could. You could have a belt, your guns slung over your belt and walk around perfectly fine, still subject to the laws and not going into forbidden zones and so forth. The only thing that caution people with all the time is be careful of where you're going like that, because not all people will respond well to seeing someone with a gun and ammunition out in the open like that, going into a fast food restaurant, stuff like that. And also, if there is a robbery, okay, who's the first person that's going to get shot by that robber? And it's going to be the person with the gun, because they're the ones who are perceived as the immediate threat. All right, so we talked about criminal considerations. Next, we talk about civil considerations. And what we talk about is very similar to what we talked about with the Castle Doctrine when we were talking about kind of the criminal realm. And pursuant to section 2307.601, same with criminal, there is no duty to retreat from the home or the vehicle. And also same as the criminal, a jury shall not consider one's decision not to flee. It cannot be considered by a jury at all when determining whether or not self-defense was utilized reasonably, permissibly, I should say. Now, the case that we watched, the first case that we watched that you all voted on, in the civil context, even though there were no criminal charges in that case either. So we're talking about no criminal charges in the Wisconsin case. There wasn't in the Ohio case either, the one that we watched before. But of course, in the civil case, that's still going back and forth. And summary judgment was denied in that case because the court held that, yeah, the Castle Doctrine's there, and it's satisfied that the shooter did not have a duty to retreat. However, there still are two questions that exist for the triers of fact. Number one, was there a bona fide belief of imminent harm? And then there still is the question of proportionality. So again, it just goes to the fact of there's going to be a criminal. Even if there's not a criminal, there still is likely to be a civil. And our clients need to know that, because they're not thinking about the civil when they're coming to us asking us these questions. So again, talk about beating a horse. I am, because I say it over and over and over, because without responsibility, you end up in these sorts of situations. Many of you saw in the Michigan school shooting case, it's really the first time that we saw parents charged and processed through the criminal courts. There were two jury trials. The son had gone to the school and there were 4 deaths. And the parents were both charged with manslaughter. Both went to trial separately. Both were convicted. And then just recently, both were sentenced for a period of 10 to 15 years because they had made access to that gun was available to their child. And now the trend is prosecutors' offices are going after those that are making the firearms and other dangerous weapons accessible to children or other individuals that are not allowed to have guns. They're making them accessible to them. And so I hope that this serves as a deterrent so that people are locking up their guns and making sure that people don't have access to them that shouldn't have access to them. And as I was putting together this presentation, of course, tragically, we now see it again in Georgia. In Georgia now, the father, after the FBI had visited the family home for social media posts, it's alleged that he purchased an AR-style rifle for his son. We all know, unfortunately, what happened last week with several killings at a high school, and the father now, as it reads here, case against father of Georgia school shooting, suspect tests the limits of parental blame. The question is, can parents be held criminally responsible for their children's actions? This father faces 4 counts of involuntary manslaughter, 2 counts of second-degree murder, and 8 counts of cruelty to children under the second degree. And so, again, it's easy. Keep everything locked up. Make sure your clients know that. They've got to keep everything locked up. You cannot be too safe. All right, so we got a couple minutes here. Some of the things to help you or your clients stay in compliance with the law. Talk about reciprocity. We don't have a blanket policy in the country where the laws are the same from wherever you go. It is different in every state. And so what I do here is, let's suppose for a moment you're traveling East Coast, West Coast. You have passed through 10 different states, and every one of those states is going to have different policies on the way that you can transport the firearm, on the way that you can take it out of the vehicle, perhaps how long the gun is, perhaps what the ammunition, the magazine capacity is. The list goes on and on and on and on. And the responsibility is absolutely yours to know and to be in compliance with those various state laws. So what I tell clients all the time is, when you are going through states, map it out. Take the time beforehand to absolutely map it out. The easiest thing you can do, just on a Google search, all you have to do is just type in firearm reciprocity United States. And what you see here is you get pages worth of maps of all the different laws that are in place in every different state. And the reason I've got a stapler on here is I tell them, before you start that trip, print out the laws in every state. Staple them, put them in a folder, and carry them with you throughout that state, because chances are you're not going to remember when you're leaving Ohio what they are in Utah by the time you get there. And if you are pulled over and you made a mistake, I'd much rather somebody say, look, I tried to have my best, here's everything that I did, and to show that compliance and that intent that's there. So kind of it's basically an itinerary for firearms law and transportation, utilization, possession in other states. And I have found that has kept people out of unnecessary trouble. So constitutional carry states versus CCWs is a very common question. If we're constitutional carry state, why do I even have to get CCW? You don't, but there are some differences. I recommend that people get a CCW, and I'll tell you why in a moment. But the CCW allows you to go into the school zone, the pickup, drop-off zones, without having to separate the firearm and so forth. Constitutional carry does not give you that ability to do that. The reciprocity, right? Reciprocity recognizes from one state to another those with concealed weapon permits. So for reciprocity in travel, someone's going to want their CCW license in Ohio. And vehicle transport, now this is where it gets a little tricky. The way that the constitutional carry provisions have been written, I think the intention is one should be able to carry a firearm in the vehicle just as one can with a CCW. The only difference, though, is, and we'll talk about it here, the laws have not been changed yet to meet kind of the status of where we are with constitutional carry. And by that, I mean, just by way of example, the Ohio Revised Code 2923-16, which was effective in April of 2023, says that no person shall knowingly transport or have a loaded firearm in their motor vehicle in such a manner that the firearm is accessible to the operator or passenger without leaving the vehicle. And it talks about how it's going to be done in a closed package or box, compartment that can be reached only by leaving the vehicle and so forth. And the only exception to that in the law that was written in 2023 is if someone has a CCW. So now I think if you get charged with a crime, you could take that to the prosecutor and they likely would do the right thing. At least one would hope they would do the right thing, but it certainly gives probable cause to an officer to enter into the vehicle. And you don't know, maybe the prosecutor says, I'm sorry, we'll find out what the law does here. But the law is clear and you did violate the provisions of transportation. So lastly, the only other reason I would say to get a CCW is because if you or a client ever does find themselves in a situation where they are being judged on self-defense, I've spoken to many, many jurors. And the one thing that they want to know is, and they look more favorably upon those who have trained, they look at the person who gets the CCW as a more responsible party, someone who's taken the time to train, someone who's taken the time to be careful, considerate of their safety and other safety. It's only a positive for the person that has the CCW. Versus if the other person gets up there for constitutional carry, says, yeah, I went to the gun store, I purchased a gun, end of story. Or I've gone to the range a few times. That's a different sort of person. So I, as a criminal defense lawyer, would much rather have a former to be able to bring before a jury than the latter. All right, now, question asked all the time, particularly with the legalization of marijuana in Ohio. If I utilize marijuana, or I have a medical marijuana card, can I have a gun? The answer is no with an asterisk. And no means you can't do it for several reasons. Even though the state says it's legal to possess and use, it is a disqualifying factor for to have a firearm under federal law. And if you fill out the forms when you go to get a gun and you lie on that form, then you're going to be in violation of filling out being dishonest on that form. Under the federal law, if you possess a gun and you utilize marijuana, it's a 922 effect, it's a federal felony, you'll be dealing with that. And so it's pretty clear with the exception of the asterisk. And the asterisk is this morning, a case was presented to me, state of Texas, and the Federal Court of Appeals just recently determined that being a marijuana user should not be an automatic exemption from being able to possess a firearm. The court stated there may be times where someone's using, obviously you don't want someone under the influence, but if someone is sober, they should not be prevented from having a firearm. So that is brand new case law to take a look at as well. But for the most part, excuse me, the law at this point is that you cannot. Now, can you be a provider or caregiver or taking that marijuana to somebody? Yes, you can. It's just being a user. And if you have a medical marijuana card, you are not allowed to get a gun. If you forfeit that medical marijuana card, it's 12 months from the time that you forfeited it before you are eligible for possession of the firearm. If the card expires, it's 12 months. So these are the things that need to be found out. So a lot of people say, well, I just got rid of my card, now I can get a gun. No, the answer is only 12 months from that. I'm going to go quickly through these last slides. Can somebody bring a gun into a bar? The answer is yes, but not if you're drinking, not if you're utilizing any drugs, you're not under the influence. You cannot consume any alcohol. It's not just, oh, is it a 0.08? No, you cannot consume alcohol at all. And that is also assuming that firearms are allowed on the premises. All right, so again, safes, locking them up, all of these things go into the determinations of did someone act with due diligence? Did they act diligently? Is it considered reasonable? Did they act with reason, which is the benchmark used in the court to evaluate parties' decisions? Were their decisions legitimate? Were they made to address a specific issue at the time? Were they fair, proper, moderate? And as we kind of come to a conclusion in the last two slides, I will simply say this. Go to the Ohio Attorney General's website, the Ohio Concealed Carry Laws book. They're all there. It's no more than 30 pages. But I caution you and caution your clients that even within this book, which this is the 2022 version, the Attorney General says the explanations in this publication of law regulating the carrying of a handgun is not an exhaustive list. And if you have a question, consult a lawyer. So knowing this area of law is very valuable to our clients because even the absolute most authoritative publication from the Attorney General's office by their own acknowledgement is not comprehensive. Lastly, we'll talk about gun trusts. People call me and say, should I get a gun trust? And a gun trust is not for every sort of gun. If you just have a handgun, no, that's not what a gun trust is. It's the National Firearms Act and Gun Control Act of 1968, call them NFA gun trusts. And they're really made to help with future transactions for certain types of guns. If you have a gun here, you've got an automatic weapon, short-barreled shotgun, silencer, short-barreled weapon, anything of the sort, that is an NFA eligible firearm for a trust. You can buy these if you've passed an ATF check and gotten the tax stamp to get all these things. But you're the only one who can possess it unless you put it into a gun trust. That allows future transfers between you and any of the beneficiaries that you've named. It allows multiple owners. If you die, it does not have to be probated. The guns can be transferred to anybody named in those trusts. So it just makes it a whole lot easier. And that, everyone, is the end of the presentation. I appreciate it very, very much. And again, I'm honored to be here. Thank you very much for your time and voting and so forth. And I wish you a great day today. Thank you.
Awesome presentation, Ian. Thank you so much for your time this afternoon. There were some minor questions that came in,
Sure.
but I was able to answer them myself. So like someone asked what a CCW was, so I was able to answer that. Unless if you wanted to expand upon that.
So the CCW is carrying a concealed weapon. So we have open carry. So if I had a firearm on my hip here that everyone could see, I can carry that around. That's considered an open carry. If I have it under my jacket where it cannot be seen, that is a concealed carry. And when we talk about CCW, that is someone who is permitted to carry a concealed weapon. And to get a concealed weapon, you've got to take 8 hours of training by a certified program, 6 hours of classroom time, and 2 hours of range time, live fire range time, where certified instructors teaching you actually how to shoot. So 8 hours in total. You get your CCW license, and it lasts for 5 years. You can renew that at the end of 5 years just by going to your local sheriff's department and getting that. When you want to get your CCW, you get your certificate from an accredited carry concealed weapon course, and you take it to either your sheriff or in the county that is adjacent to yours where you live.
Beautiful. Yeah, no further questions from you. Everyone, thank you for tuning in to this presentation. I will get the CLE survey out to you. Just complete that to get your credit. You're getting words of thanks, Ian. I'm not sure if you can see those, but thank you again. And we'll catch you next time, everyone. Have a great afternoon.
Bye-bye, everyone.